Steele. Well, I mean, the warrants would supplant, the certified copies of the warrants that you have at this point in time would supplant Mr. Steele's argument. But still the problem that you're going to have is that 17-5-30 would have required you to still return that particular property. There's no case law which indicates that particular issue, and the statute is pretty clear. It says, you know, motion, if the motion is granted, because Judge Newkirk granted that motion, and it shall not be admissible against evidence of movement in any trial. So basically, you know, you're getting a second bite at the apple, and that particular circumstance. That's why the legislature makes some very specific issues about 17-5-25, which is execution of warrants, 17-5-30, which is motions to suppress, and then 17 17-5-54, which is different. That's trial disposition of property. So in that respect, that's why in this particular circumstance, you all still, now if you've got another argument as to why you didn't, I mean, other than why you, and just hear me out. You didn't have a valid arrest warrant to begin with. Now you got one, but you didn't have one when you had one in front of Judge Newkirk. You sought a search warrant, so you weren't in the right place and space to begin with, because you went in the house, somebody saw some marijuana, or somebody saw whatever it is, and they, in D10, they got they drew an affidavit, and they said, okay, we want to search the house. Well, you got to be in the right place and space to begin with to have the authority to search the house to begin with. Mr. Steele and his motions asked for suppression of anything that was taken in the house. So marijuana and anything else that was the basis of that. So that's fruit of the poisonous tree. He's argued that all throughout his motion. He's argued that. And so Judge Newkirk, by implication, had to consider it as part of his ruling. So you asking me to kind of, okay, well, the marijuana's over here, that's fine, but he didn't suppress the other stuff. We can still use it. That's not the way I interpret this particular scenario and interpret the law related to search and seizure of this particular item.